Ready, start. Undoubtedly, the High Courts should discourage writ petitions or petitions under Section 482 CRPC where alternative remedies are available. Nonetheless, as observed even in Sakiri Vasu versus State of UP, it is equally true that alternative remedy is not an absolute bar for invoking the extraordinary jurisdiction or the inherent jurisdiction of the High Court under Article 226 of the Constitution or Section 482 CRPC. In Ramesh Kumari versus State (NCT) of Delhi the court denounced the dismissal of the petition seeking registration of the FIR solely on the ground of alternative remedy and held that ground of alternative remedy would not be a substitute in law for refusing to register a case when the complaint of the citizen makes it a cognizable offense. In a recent landmark decision, Anurag Bhatnagar and another versus State (NCT) of Delhi and another, this court held that although the complainant approached the court in that case, the magistrate without exhausting the alternative remedies available, it was a mere procedural irregularity and not illegality as the court was competent to order registration of the FIR. It was further observed that when information disclosing commission of cognizable offence is conveyed to the police, they cannot refuse to register the FIR. It is the duty of the police to register an FIR if a prima facie cognizable offence is made out. The police is not required to go into the genuineness and credibility of the said information. It has been so laid down very clearly in Ramesh Kumari (Supra) that the genuineness or credibility of the information is not the condition precedent for registration of an FIR. The complainants Sis Ram Sani and Vijay Kumar Agrawal have approached the police authorities by means of complaints dated 5/7/2001 and 23/2/2004 to get the matter investigated, but as no action was purportedly taken thereof, rather it is alleged that the police authorities expressed reluctance to entertain the complaints as it would not be proper on part of the police to investigate against the officers of the CBI. The complainants approached the Constitutional Court for necessary action. Therefore, if the Constitutional Court has exercised its discretion in entertaining the petitions and directing for the registration of the FIR against the two officers on being satisfied that the commission of a cognizable offence is prima facie made out against them, we see no good reason to interfere with such discretion. At best, as argued by Mr. Ranjit Kumar, we can say that the opinion expressed by the High Court in regard to commission of the cognizable offences is only a prima facie opinion and has to be treated as such so as not to affect the discretion of the IO subsequent to the investigation. The registration of the FIR against the two officers is not likely to cause any prejudice to them. They will have the right to participate in the investigation to establish that they have not committed any such offence as alleged.